And now it is my pleasure to welcome UNL School of Law's distinguished professor, James Ellis, who will moderate our next panel on the role of state constitutions and Supreme Courts in the provision of civil rights. Please join me in welcoming Professor Ellis and our distinguished panelists.
I'm aware of the fact that this panel has distinguished. Okay. I'm aware that this panel, as distinguished as it is, suffers the disability of being the only thing standing between you and hearing from Rob Schwartz again, and we'll try to keep that in mind. We are here to talk about the more particular approaches to state constitutions that Justice Daniels just talked about, having had the more high-flown morning presentations on philosophy of this and medicine of that. When we get down to how do you do litigation under state constitutions, my understanding is that this is the Eat Your Spinach panel. That you've received your reward earlier, and now it's time to pay up. Let me talk about our distinguished panel, and I'll start with the lawyers. Andy Schultz, whom most of you know, 1984 graduate of this law school and is a partner at the Rohde Law Firm here in town. He has also been an adjunct professor here, and that is a measure of the generosity with his time that he serves the law school as adjunct and in other roles just for a little while, the last 28 years by certain counting that he has taught here. He obviously has a strong interest in constitutional law and civil rights litigation. On the other side, Laura Shower Ives is a partner at Kennedy and Ives. I hope I got all the Kennedys in. If I did, if I left one out, it was probably the most important one. And I apologize. Where she does civil rights law. She was previously the legal director of the ACLU of New Mexico. She has previously litigated on state constitutional claims involving same-sex marriage, physician assistance in dying, the right of independent theaters to show dirty movies. Capturing her attention has remained a challenge. Her federal constitutional litigation includes freedom of religion cases under the First Amendment, veterans cases under Don't Ask, Don't Tell, and many, many others, particularly involving use of force in the Fourth Amendment. Turning now to our judges, both of whom you've heard earlier today. Chief Judge Linda Vanzi, the Chief Judge of our Court of Appeals, which is located in a very nice neighborhood, has, since she was a graduate of this law school, been interested, obviously, in state constitutional law. We all already heard her on some of the particulars, but it's our hope that this panel will allow the panelists to talk a little more generally and more freely about the role of state courts rather than the particulars of an individual case. And Justice Daniels, whom you just heard from, is still what he was a few minutes ago. Unless I've missed something.
I'm increasingly aware that I keep getting older.
The clock has turned off. He has been a justice of this state Supreme Court for the last 10 years. When Rob Schwartz was up here, he revealed, for whatever reason, that he had been an applicant for two of the positions on the Court of Appeals of fellow panelists. I will reveal that I was a co-applicant with Rob Schwartz for the job that I now hold. And we both got the job. But what is maybe less well known, it is the job, we got the job because Justice Daniels had chosen to go someplace else. It had previously been his position. But with that out of the way, let me talk a little bit about state constitutions and the importance of the text of state constitutions and taking state constitutions seriously rather than, oh, nothing else worked, let's try that. You heard our luncheon speaker talking in particular about the importance of teaching and practicing with state constitutions. A few years ago, I was asked to give an address to the National Association of State Supreme Court Chief Justices. There is now officially a National Association of everything. And so I had the Chief Justice of the 50 states there, and I was supposed to talk about mental disability stuff, and as just a throwaway line at the beginning, I said that it had been at least 20 years since I'd given a constitutional law exam that didn't have a state constitutional question in it. And suddenly they all stood up and there was this standing ovation. These were people who apparently appreciated that someone recognized that they had important work to do with regard to their state constitutions, as indeed they and the other judges in our state systems do. We heard in the last presentation about the particulars of the importance of the way in which state constitutions get approached and the prevalence, other than for matters like separation of powers between the governor and the legislature, which they sort of have to sort out, the prevalence prior to the last 40 years or so of the why are you bothering me, it's nearly lunchtime approach to claims under, in particular, the individual rights provisions of state constitutions, and how state courts have begun to take much more seriously their approach. New Mexico is not unique in having started off with what in the federal level would be Fourth Amendment cases in lots of states. That was the first point of departure, but it has spread to many others. I would just offer one other notion in this, which was mentioned in a different context earlier on. The Supreme Court of the United States, Justice Brandeis referred to our state legislatures as laboratories of democracy. In a different sense, our state courts are laboratories of democracy, and we can all learn, and the federal courts can learn from the experience of state courts in adjudicating important and, in particular, novel and difficult cases. There was also mentioned earlier, and I guess I'd like to start with this, and perhaps we can start with our judicial panelists and then turn to the attorneys here. There was reference to the fact that depending on how you count, between 40 and 47 states have some form of election for their judges, or some form of political accountability for their judges. And while states have been, when they were devising their state constitutions, have been very, very prone to copying stuff from the federal constitution, the thing that almost no states followed was Article 3 and the protection of their judges from political accountability. So I would start off asking anyone who wishes to talk about what political accountability means and what elections mean as you confront your tasks, and then the lawyers in approaching you all.
I'll be glad to do that. Actually, when we became a nation, we started out following the federal model, which was based on the British model that judges were appointed for lifetime during good behavior to sort of insulate them from the storm winds of political elections. It was during the early 1800s in the Jacksonian era when our country suffered a great democracy scare, I guess you'd call it, that we ended up in all the states starting to elect every official. I bet some of you don't know the qualifications of your state auditor candidate and your county clerk candidate and all that. people definitely don't know the qualifications of judges that they vote for, but notwithstanding that, under the Jacksonian model, and the model that was used in New Mexico for many years, the people had the ultimate power in theory to select and deselect their judges through political elections. I say in theory because in theory there's no difference between theory and practice, but in practice there is. And the theory doesn't work out in practice because the people aren't making informed choices about their judges. And we've seen a lot of abuses throughout this country since the Jacksonian period, where we went from protected tenure judges like the federal courts still have, it's written in our federal constitution, and instead of having these wide open judicial elections, campaign contributions, campaign ads, those dark, slow moving figures on TV that the attack ads have and all that, and sometimes millions of dollars contributed to campaigns, particularly in other parts of the country. New Mexico hasn't had the worst of that yet. But in New Mexico, we changed to a combined system in the 1980s. There was an attempt to get what's commonly called the Missouri Plan, where there would be a vetting panel, a selection commission, that would review the qualifications of candidates for judicial office and submit a most qualified list to the governor or other appointing authority, usually the governor in most states like New Mexico, and the governor would have to pick from that list. So they would knock off the worst ones, the incompetent ones, the corrupt ones, the unqualified ones, and give the governor a fail-safe list and say, Governor, you can do your mojo, whatever you want to do. You want to pick your own political party, but you can't get somebody unqualified to do it. And under the pure Missouri plan that some states have, the judges would stand before the electorate, but not in a partisan election, not on a party label, not with an opponent to do those nasty, dark, slow motion ads and not let all that money coming in. It's just a pure retention election. Should we keep this judge or not? And if they're not kept, then the process would start all over again. So I think that provides a good check for the democracy without the worst excesses of the elected system. But we ended up with a compromise. As is often in the political arena, there were forces on the other side who wanted to keep the pure political system, either in theory because they thought, well, that's the right of the people, or out of practicality because some of the people in the legislature opposing it liked this election system, thank you very much, and so did their buddies that they were helping getting into the judgeships. And so we ended up with a system where we go through the merit selection. The governor appoints only from the list from the Merit Selection Commission, and the judge starts work, but then for the first political cycle, they have to go through the whole traditional political thing where anybody can run against them, whether they were rejected as unfit by the Merit Selection Commission or just bypassed it entirely and decided just to run. And you have to win the primary election in whatever party you're in. If you're not one of the major political parties, you're toast. That's the reality. So you have to be in one of the major political parties and win both the primary and the general election. And once you go through that, which I compare to a fraternity hazing process when you first get on the bench, then you lapse into the merit review of the retention election after that. So we still have parts of the worst. We have parts of the best. It's like a lot of political compromises. I think traditional political elections are dangerous for the judiciary because you see in other states judges running based on how many people they've put in the death chamber. How Judge so-and-so sentenced a defendant to 500 years, as if the difference between 400 and 500 is that significant. But you'll see those kinds of ads that pander to the worst reasons we ought to be selecting and deselecting judges. And in New Mexico, we actually have an assistance to the voters in the Judicial Performance Evaluation Commission that the New Mexico Supreme Court set up in the late 1990s to provide a broad-based, politically balanced review of the work of the judges. They study our opinions, they study our timeliness, they study our temperament. They talk to lawyers who come before us, they poll jurors and witnesses and other folks and say, does this person have a good work ethic? Do they treat people fairly? All those kinds of things. And they put together, and they interview us and point out our deficiencies. All of us go through that, and even at the Supreme Court level. And I think it's a very healthy process. And then, most importantly, they submit a report to the voters. It's on the websites and newspaper supplements. And I have good news. I calculate that 17% of the voters read those things. And, well, you can see from the election results that it has some effect. It's not an overwhelming effect. Obviously, most people don't read it, but at least they have it available, the voters, if they want to see who's doing a good job and who's not doing a good job. So other than that one political election cycle, I think New Mexico has a fairly good system. There are some problems with the federal system. You know, they say in the United States Supreme Court and the other federal courts that a federal judge gets appointed for life and a reasonable time thereafter. And, you know, and virtually they're in there. They have to be really bad. I'm going to just mention this one example and then pass this over. I realize I'm talking long and answering this. I had a case once when I was a lawyer in a federal court in Las Vegas, Nevada, where this judge threw us out of court for reasons I couldn't understand. I didn't find out until I was on appeal in the Ninth Circuit when he got indicted for not paying income tax on his bribe money, what had happened in the case. And he got convicted and sentenced to federal prison in Atlanta, and he refused to resign. He kept getting his federal paychecks in the federal prison in Atlanta. He had to be impeached by the Senate. I mean, it's very rare that they'll impeach a federal judge. So I think that maybe the retention system we have is even better than the federal system, Jim.
May well be. Chief Judge Van Zee, if you would talk a little bit about accountability and what it means in terms of the work you do.
Fortunately, nobody cares about the Court of Appeals. We're the under-the-radar court. They figure if we've got it wrong, the Supreme Court will straighten us out. And I don't know anybody on my court or any of my colleagues that would bend to public pressure on anything, any of the work that they do. If we spent our time looking over our shoulders on every criminal case, every civil case, we'd never get any work done.
I think that distinction between the state's highest court and lower courts with elected judges is an important one. The example that was given this morning about the Iowa justices who lost after a decision on gay marriage, and more famously, at least for those of us of a certain generation, when the California Supreme Court had 3 of its 7 justices defeated for election. California kept track, or scholars in California kept track of what the no votes were on the retention elections. This is not, you're not running against anybody, it's a thumbs up or thumbs down. And the thumbs down number, the failed number of people who voted no but didn't throw this person out, had gone up incrementally in every election until it reached critical mass when Rosebird and Cruz Reynoso and Joe Groden were defenestrated from the California court. That I think, I don't think that comes up as much for lower court judges. It may not come up more for trial judges. If you're doing the O.J. Simpson case and your name's on the ballot the next time, people might notice. Let me turn to the lawyers.
Well, so one, I'd like to say I wish there was a do not retain for the U.S. Supreme Court. That'd be fantastic. And second, in working on the same-sex marriage litigation, the folks that we worked with who had long experience, long history doing that work, were well aware of the potential for the judiciary to be cautious, especially in the wake of Iowa. And what their strategy was, after very early judicial defeats, was to really start a public education campaign, which is what Dean Chemerinsky mentioned earlier as well. And the problem I see with the public education campaign, to sort of bring the judiciary around, to bring the majority of Americans around at the time when the Supreme Court finally ruled in Obergefell, is then you're just not protecting minority rights, which is what the Constitution demands the judiciary do. And, is there interplay between the public education campaign and what the judiciary feels comfortable doing? It seems like there is. And I think that is an unfortunate consequence of Scalia, Rehnquist style criticism of justices for protecting the social contract that we've made.
Well, the direct answer to your question is, as lawyers, we have no accountability, so it's very simple. But I want to pick up on something that Judge Vanzi said. One of the most remarkable things is, in our practice, we work with lawyers at national firms a lot. And whenever a case gets filed here, inevitably one of the very first questions they ask is, when we are in state court, particularly trial court, A, they want to understand how our judges are picked, and number two, they want to know when the next election our judge will have. First, they are shocked when I give them Justice Daniels' explanation for how our judges are picked, because after I finish that, inevitably the first response is, "You're kidding." But to Judge Vanzi's point, the perception is, particularly from out-of-state counsel, that particularly trial court judges are subject to electoral whims. And that's why that's one of the very first questions all out-of-state counsel want to know is, how are our judges picked and when is their next election?
I would add to that, that there is, in addition, among the electorate, there's a reason that the states didn't follow Article 3 or ditched it in the Jacksonian period, which is, what do you mean I don't get to choose? Which prevailed at the level of everything short of school crossing monitors. That if someone were to propose, the federal system works pretty well, maybe we should have justices and judges appointed for good behavior, for life. The groundswell of support that we get from the public would not change the Earth's gravitational force. That is not a seller. So that suggests that the people think that the judges they're electing are their representatives. That those judges are there to carry out what they want those judges to do in the way that their legislators are supposed to carry out what the people want them to do in voting. How do you persuade voters that is somehow impermissible in a judicial electoral system?
It's very hard, because voters don't want to hear that what you're going to do is be fair. That's the last thing they want you to tell them.
That's like asking, how do we teach civics better? Because that's something people ought to learn in school, long before they get to college, about the role of their government and their part in their government's operation. They have to be informed and make decisions, and not that they always are, but that's a responsible of citizens in a self-government like this. I do a lot of speaking, I'm sure Judge Vanzi does too, to Rotary clubs and League of Women Voters and Daughters of the American Revolution, any group that wants to find out about the system, because I think it's a responsibility of all public officials, including judges, to help inform people about principles of civics like that. That judges don't represent their personal preferences and can't. They have legislators they get to vote for to do that. They can vote for governors to do that. They can vote for presidents. They can vote for those political representatives, but what they should expect from judges is an obedience to the laws that are created through that process, the statutes that are enacted by their representatives, the constitutional provisions that their own predecessors enacted into law, and the judges have to place obedience to the law over obedience to the current popular whim. And people, when they think about it, when they stop and think about it, when you talk to them about it, they say, oh yeah, that is a better thing. I don't want judges to just be blowing in the wind. I want some kind of stability in this whole process to make sure that the law is followed. But it's a real process, helping people think about their roles in our government.
There is a focus, and we heard it earlier today, at the federal level, probably echoes of it some at the state level, of focusing on which political party the president who appointed a judge was from. And there are 5 who were appointed by Republican judges, or they're let's make it 6 or 7 members of the state Supreme Court so that we're not doing an actual count, who were appointed by a governor of one party or another. In the federal system, there's not much anybody can do about that. In the state system, that is something that is out there, that it's not only what has a judge done as a judge, but how'd you get there? And I'm wondering to what extent that plays out, or is part of the consciousness that you have as judges or that lawyers face in deciding those before whom they're going to appear.
I have a great revelation for you. Governors appoint their friends and not their enemies to any office. That may be a great revelation, but that's just reality. There's actually no perfect system of selecting and deselecting judges, just like there's no perfect system of government, like no perfect system of anything in human affairs. You can always find flaws in each of them, including in the federal system of appointing judges for life. But the reality is that governors generally appoint people in their own political party, if all of the things being anywhere near equal, rather than people in another political party. It's just part of the human reality. The advantage of the merit selection process that we have in New Mexico, except for that one chaotic election, and Judge Vanzi and I have both been through this. I don't know of any judge who's been through it who likes it. But other than that, we have a system that's designed to take politics out of it as much as you reasonably can do, to provide that fail-safe list to the governor so that the governor can't use political considerations alone. They have to work merit into it because they're limited to the list that's recommended by the Merit Selection Commission. And then in the retention elections, there are no party labels and no opponents, and that takes out the politics in large respect. I'll tell you from my experience on the state court in New Mexico, we have a lot of good judges in New Mexico as a result of the merit selection system over the years. No group of humans is always perfect, none of us are. But we have a good set of judges, and I'm going to tell you publicly, it doesn't make any difference whether they came onto the bench as Republicans or Democrats. Most of them try to do the job well, and I think you can't separate the good ones from the bad ones by political party. So I think we've taken out the worst of the political aspects in New Mexico.
there remains, and you were alluding to it, the popular perception that judges are politicians who wear robes, or judges are politicians who don't have to wear pants to work. That this is all nice and pleasant sounding pieties, but that it doesn't accurately describe what judges do, and combating that and finding a way to persuade people. Justice Daniels said it's part of teaching civics, which carbon dates you because we don't teach civics anymore. That has come and gone. Let me elide over into the way in which this plays out in the topic for this symposium, and in particular the interpretation of state constitutions. Every state has a constitution. As I say, it was generally honored in the breach for a long time. It is now being taken more seriously. How should a judge approach the text of its constitution? Is the fact that they are free to interpret their constitution differently than the federal courts interpret the federal constitution, so long as they don't provide fewer rights? Is that just, oh, here's something fun we can do, or is it something that can and should be rationed? How do you approach the state constitution?
I'll take a short hit at this and then pass it down. And I won't talk about how I would approach interpretation. I think the first issue is who brings the cases before the courts. And Professor Chemerinsky talked about this, about state constitutional law needing to be taught in law schools. Wendy Jones and I were talking that probably we took one of the last state constitutional classes offered at this law school in 1994. It's been a long time. And Justice Daniels talked about the use of the state constitution in what has turned out to be mostly criminal cases. Professor Browdy wrote a couple of law review articles on State versus Gomez. And in 2010, he said that Gomez had been cited in 81 Court of Appeals decisions, 54 of which were further reviewed in the Supreme Court. And I think by this point, it's been cited like 545 times. Lots and lots of criminal law cases and asking judges to interpret Article 4, Section 10. Very, very few civil cases have been brought in the same amount of time. Since in the last 25 years, I would say there have really only been 3 big cases involving individual liberties. The first was the NARAL case. And in that case, the New Mexico Supreme Court did not accept the invitation to expand the Due Process Clause or the Equal Protection Clause, but instead used the state ERA, which had no federal analog, to decide the case. Then, several years later, there was Griego versus Oliver, and now Aiden Dying. So while State versus Gomez has been cited over 500 times, there have only been 3 significant, I think, individual liberties cases in all of that time. And if lawyers are not bringing the cases and not educating the judiciary as they go along, it's very hard to say how the judges are going to then interpret the state constitution.
And I want to...
That was your, that was, yeah.
By the way, this part was rehearsed, but there's a reason for that. In the federal system, Congress passed the Federal Civil Rights Act. That legislation allows people to go, and they can go to federal or state court, to bring a suit to enforce federal constitutional law. And not only do they have what's known as Section 1983, which is the substantive part, they passed a kicker, which is Section 1988, which says to a lawyer, if you bring this case and you prevail, the government pays your attorney's fees. As a result, we have seen this explosion of federal civil rights law in the federal system under the Federal Civil Rights Act. New Mexico does not have any statutory mechanism to bring a civil rights claim under our state constitution. And let me be very clear about this. I mean, Justice Daniels, all the cases you talked about, the Fourth Amendment cases, these are people who are raising our state constitution as a shield. They are telling the government they can't do something. Evidence cannot come in because of a state constitutional protection. But what about the situation where someone comes in to Laura's office or to my office and says, I believe my state constitutional rights have been violated. What can we do? Well, number one, there is no state civil rights act, so I don't have a statutory means, like in the federal system, to file a suit for damages. Now, I can sue for an injunction or for declaratory relief, except for one of the cases that Judge Vanzi mentioned, which is the Narol case, where the New Mexico Supreme Court said, yes, you can bring this case, and if you prevail, good for you, you can't get your attorney's fees. So for the vast majority of lawyers, there is no incentive to bring a state civil or a state constitutional claim because, number one, there's no statutory mechanism, and number two, if they win, they can't get paid. Well, there are a couple of options that they have left, but they're not very satisfactory. There's the Human Rights Act. That allows for attorney's fees, but that really only covers a very small number of things. It covers discrimination. There's our Tort Claims Act, but then you're forced to take a state constitutional protection and try and shoehorn it into a tort for only 8 limited exceptions set out by the Act. So for the most part, you can't do it. So, I mean, Judge Vanzi, I think there's a very good reason you're not seeing, and the way Professor Chemerinsky talked about it at lunch, you're not seeing these cases with the state constitution being used as a sword, going into court, trying to expand the scope that's already provided in the text. There's just no way to do it.
Let me turn to Laura, and with her ACLU of New Mexico hat. Do you think there's an appetite in the legislature for creating something that would make it easier? You spent time up there.
I thankfully didn't spend much time up there. I mean, the difficulty is that costs the state more money. And I imagine in any analysis of that legislation, that would be the case. But in the long run, and I think we're seeing this with the restriction of federal civil rights, and I think like the Albuquerque Police Department was a good example of this. When you violate people's constitutional rights and you create a culture where that's accepted, and that's happening in the federal judiciary with qualified immunity, that eventually is actually going to cost municipalities more money because the violations become more and more egregious, and eventually they're going to get hit. And I think ultimately the same would be true with a state civil rights enabling statute. It's the reason Congress passed that, and the federal version in the 1960s is because that's good government. We are better as a people. We are better governments when we follow the Constitution, and I think ultimately it would cost the state less.
Jim, you were asking how we approach constitutional interpretation. I think essentially we approach it the way we approach the interpretation of statutes or rules or other provisions of law. We try to understand, what's the purpose of this? What was this intended to accomplish? How does it fit in here? And how do we apply it here? The main difference is in intensity. When we interpret a state statute as meaning something, the legislature or the people electing different representatives to go to the legislature can change that. can change our interpretation. And that happens sometimes. We'll interpret a statute in a certain way, and it doesn't square with what people want at that time, so they'll amend the statute, and then we have to apply that statute. That's our job as judges, recognizing the right of the legislature and the people who elected them. But when we interpret the Constitution, the legislature and the people are powerless to change the result except by amending the Constitution. And I think that imposes on us a greater sense of responsibility of the magnitude of the decision that we're making. I think ultimately we have to make the decision in the same way. What is the purpose of this? What is our best judgment as to how these words on paper should be interpreted and applied? But we have to be aware, if we're doing our jobs right, of the enormous consequences of making a constitutional decision instead of a simple statutory interpretation.
And one of the differences, we've talked about the difference between the federal and state judges in terms of the appointment process, but another difference to keep in mind is that amending state constitutions is incredibly easy as compared to the process of amending the federal constitution. I can remember times sitting in judiciary committees on some different bill or whatever, and something would have come up on a proposed constitutional amendment that had some controversial aspects. And legislators would openly say, well, I'm not really voting for this, I'm just voting to send it to the people. If it were a statute, I'd take it seriously, was the undertone, which is a little disquieting. But let's shift from that to the other things that are at hand, and starting with, as you're interpreting a state constitution or as you're arguing for the interpretation of a state constitution, in what way might originalism either matter or not matter? It matters obviously a lot with regard to other sorts of cases, and the U.S. Supreme Court takes it seriously on some things and not on others. The language in the state constitution that's at issue may have been hard fought, and we know a lot about where it came from. It may have been copied down from the federal. It may have been copied down from the state that somebody was from who moved here. Is originalism something that we should take seriously? Is it a useful tool for those of you who are litigating under the state constitution? Well, this language came from here, and therefore it must mean that.
Well, I mean, I think we're forced to address originalist construction. And so for the New Mexico Constitution, given when it was adopted, I point to Article 2, Section 4, which is the happiness clause, which is a very clear statement, I feel like, that the contract between the people of New Mexico and the government is that the government is not going to infringe on your right to do much of anything unless it has a good reason. And to me, that particular clause just looks like a harm analysis sort of clause of governance. And cases could be potentially very easily resolved, like stop signs, of course. The harm is you're going to run the stop sign and hit people. And in cases like aid in dying or marriage, where there are these fundamental autonomous decisions at stake, that clause could be used to support the right to make decisions, basically when your decisions don't harm other people. That clause, it was given prominence in the Griego opinion, and it is now less useful as a result of the Morris opinion. But there are distinctive clauses that should have more meaning than statutes.
I think it makes a difference depending on what your concept of originalism is. If it is exactly the way the provision of the Constitution would have been interpreted in 1789 under the U.S. Constitution, for example, or in 1911 when we adopted the statute the Constitution of New Mexico before we became a state in 1912. That's mindless originalism. They didn't have cell phones then. They didn't address whether you have a right to privacy in your cell phone. They didn't have airplanes then. Well, I guess in 1903 they had the first airplane.
In North Carolina.
Yeah, but circumstances change. But in the sense of trying to figure out what was this provision about, this right to be free from unreasonable searches and seizures, this right to freedom of speech, what was it the framers of the Constitution were trying to get at here when they wrote this? In that sense, I think you want to look to see what the original essence of the intent was and interpret it in light of modern manifestations of that kind of right, whether it's a right to privacy or a right to speech. We didn't have televisions and radios in those days. We talked about freedom of the press, but the essence of the concept was a freedom to express yourself through the available media outlets, and so that applies to TV stations, even though Madison and Jefferson and Franklin and all those others never thought of television sets. So mindless originalism is not being true to the essence of what the founders created for us. But I think that we need to try to think what this was getting at. What kind of guarantee was this? And so you look at it and make a decision that judges are required by law to do. Judges are supposed to make judgments. You have to use some judgment in deciding these kinds of things and not just feed it into a computer program.
A former Chief Justice of the Supreme Judicial Court in Massachusetts, earlier in his career, disparaged the extension of that and described it as a picnic theory in which the framers brought the words and the judges get to bring the meaning, and that the framers, the drafters' influence ended the minute the ink dried. How do you get past the objections that the dead hand of the drafter should control what modern cases turn out to be?
Well, part of this depends on which side I'm arguing.
And what is it you do for a living?
If I like the text exactly as it's written, I'm all for originalism. I want to stand up in front of Judge Vanzi or Justice Daniels and tell them, you have to do exactly what that says. If I'm not as crazy about what the text says for my client's position, I'm probably going to want to dig a whole lot deeper into what this means, what they were thinking at the time, anything to get around it. But Jim, there's one other area that I also think is important. Because Justice, your immediate assumption is that it's for the court to make this final deliberation. And in point of fact, that's not what the Constitution always says, because sort of the 3D chess model of constitutional interpretation, it's not just what the Constitution says, it's who it delegates the power to make that decision. And oftentimes the structure of the Constitution, and when you were talking about mindless originalism, this is what Justice Scalia talked about so much. For Justice Scalia, it wasn't, I'm only going to interpret the Fourth Amendment in a certain way and I don't care if cell phones were invented or not. But one of the things that Justice Scalia looked at very heavily is this something that was even delegated to the courts to do, or is this left to the states? Is this left to the legislative branch? And our job really becomes much more constrained in that level. So the answer to your question from a litigator's point of view, and I'm guessing Laura would probably agree, which is, tell me which side of the argument I'm on, and I'll tell you whether I like originalism. But more to your point, Justice, I'm not so sure that I would always agree that it's your job in the final analysis to make that decision.
One of the constant struggles we have as judges is to try to recognize what are the limits on our own power and to not exceed them. In terms of raw power, did all of you see Bananas, or am all of my cultural references out of date? The Woody Allen movie Bananas, about the Cuban dictatorship where he took over a Castro-type character and he said, from now on, Tuesdays will be on Thursdays, and everyone has to wear their underwear outside their clothes and all that. As a judge, I can write a writ saying you have to wear your socks on the outside of your shoes. I can do that. But it's not a legitimate exercise of that raw power. And as a judge, I have to constantly think about, is this my job? Is this the legislator's job? Is this a job ultimately for the people without my telling them what they should or shouldn't think in this regard? Being a decent judge requires a lot of conscious self-restraint, I think.
I just want to add one thing to that, and that is when we're talking about interpretation of federal and state constitutional law, we have to be mindful that our state constitution is in fact different than the federal constitution. And as judges, we have to consider that as well. And I'm going to go back to Professor Browdy because he was my teacher. And in his 2010 Law Review article, he said that his earlier contribution had applauded the Gomez decision because a jurisprudential approach for dealing with arguments urging the expansion of state constitutional rights beyond those recognized under the federal Constitution is of importance to a mature state jurisprudence. And I think that that's something that we have to be aware of, that lawyers, as they're coming before us, have to make those arguments, and that judges need to be aware of it as they deliberate in their decisions as well.
We have a lot of different guarantees in our state constitution, and we're not an unusual state, although we have some unique features of our own constitution. It's not just a matter of it being U.S. Constitution light, sort of a shadow of the U.S. Constitution. There are some similar provisions, particularly in the criminal procedure protections, the search and seizure and confessions and those kinds of things. General language and due process and equal protection, but we have some unique things in New Mexico. For example, we have a state constitutional provision that our court has consistently enforced that provides that nobody can be excluded from jury duty because they can't understand the English language. That's unique around the rest of the country. Other people in other parts of the country say, you guys are crazy. We say, well, this is what the founders of our Constitution wrote in it, and our job is to enforce it and not decide whether it's more convenient to keep non-English speakers off jurors. We provide the interpreters because that's what our state constitution requires, and there are a number of provisions in the New Mexico Constitution like that that have no federal counterpart. Those are, of course, the easier ones to interpret. The ones where there's an identical provision in the U.S. Constitution that has been interpreted for 200 years by the U.S. Supreme Court sometimes is a bigger challenge in going in a different direction. We have to provide more of an articulation to justify why we view those same words differently.
Let me touch on that last little bit and ask the two of you as judges and the other two as lawyers what role that plays. There's nothing in the state or federal constitution that says that the court is required to do something other than say, you win, you lose. And yet judges have, as a tradition, said, oh, we need to explain ourselves. As judges, who are you explaining it to? And as lawyers, how do you take the explanation that you have received from a court, either a case you're in or that's a precedent in a case that you're subsequently pursuing?
Our opinions are written to multiple audiences at the same time. In a real narrow view, we're explaining our ruling, the reasons for it, to the particular litigants and lawyers who appear before us. But at the Supreme Court level, they're not the most important audience, because that opinion becomes precedent, that becomes part of the fabric of the law. And we need to articulate the principle underlying our opinion in a way that people in the future can understand it not only to understand why we decided this case, to understand what their government is doing, and a government of the people, by the people, for the people ought to understand what the government is doing. And we have that obligation to explain this decision. But more importantly, we have to try to articulate any lines we're drawing, any theories that we're expostulating, so that they can apply them in their own affairs and in their own cases, and trial judges can apply them in future cases. And so that's the primary audience of these long, wordy opinions, and why we try to spend so much time. Sometimes we succeed and sometimes we fail, but why we try to spend so much time to try to explain it and try to provide some kinds of guidelines that people can use in the future. One of the most frequent questions I'll ask lawyers in oral argument, I really get a lot out of oral argument. I would advise lawyers never to waive it unless they think they have nothing to say of any use. But I'll always ask them, how would you have us articulate in an opinion the rule that would reach the result that you want here? How would you have us articulate that rule so it can be applied in a principled way in future cases? And the lawyers who've thought it out and who have a principle that they're basing their request that they win can provide that kind of articulation. The lawyers who either haven't thought it out or have a case where there is no principled justification for ruling in their favor aren't able to do it.
Once again, middle-level court. We have 10 judges who will all have a different answer as to who their audience is. Judge Sutton will tell you he's writing for the Supreme Court so that they don't take cert on his cases. Somebody else might be writing for the district judge. Somebody else may be writing for the lawyers involved. We try to write for all audiences, but if you look at our opinions, that's clearly not true, because a 150-page opinion is not being written for the pro se litigant.
I mean, when I read an opinion on a case of mine, I read it for a pretty simple purpose, to either replicate what I did well in the future or to figure out how to fight in a different way and to correct it.
Let me put Judge Van Zee on the spot. If you have a case that you're deciding and having to decide what to write, write a lot, write a little, and it's a case that you know is very likely to go up.
You mean like Morris?
Were there such a case? What do you think the function of an intermediate court is, federal or state? And what's the perception of on the Supreme Court of what help they get from the lower court, whose papers they're grading, whose decision they're reviewing?
I know I make a lot of fun of the Court of Appeals, but I think I can speak for my colleagues that we really do try to get it right, to explain the law, and to make it readable and usable for future litigants. The reality is we get about 1,000 cases a year, and the Supreme Court only takes cert on about 10 or 15% of those cases. So we are, in fact, making the law in a majority of the cases that are being decided in the state. So we try to be careful. I may make fun of it, but we try to be careful about what we're doing, because we do know we may very well be the last word on any particular issue.
Our two courts do a lot of similar work in analyzing cases and writing opinions, but we have two distinctly different functions under our New Mexico judicial structure. The Court of Appeals is the primary error-correcting court. Under our state constitution, every aggrieved party, every party who thinks they're aggrieved, every party has a right to an appeal to at least one court. The Court of Appeals performs that constitutional function of being the court of review for most of the cases in the state. Our court, since the creation of the Court of Appeals in the 1960s, has been primarily a precedent-setting court. One of the main reasons we will review a Supreme Court, a Court of Appeals decision on certiorari is if someone persuades us that we need to look at this to make a precedent or correct some kind of wrong direction of the law. And in over 90% of the cases, we deny certiorari because the Court of Appeals gets it right. And in some of the other cases we grant cert, they may have gotten it right, but we want to review it and do our job. It's not that we're smarter than they are. It's that under our system, we're the last level. We're not last because we're right. We're right because we're last. Whatever we say is it. I mean, because there's no other place to go beyond that except the U.S. Supreme Court on federal issues. And so that's a different function of our two courts. Sometimes after we hear an appeal or certiorari case out of the Court of Appeals, we'll ultimately agree they got it right. Sometimes we'll write another opinion, writing it up in our words, but sometimes we'll quash certiorari. I mentioned the trash search case that was decided under our state constitution, State versus Granville. That case was decided in 2006 by the New Mexico Court of Appeals, and they sit in 3-judge panels, so they never sit with all 10 judges on the case, never any more than 3 judges. We granted review on that case because it was an important question of state constitutional interpretation, whether you have to have a warrant to search somebody's private trash. We got briefing, we got oral arguments, and at the conclusion of that, I was on the court by then when the case was argued to us. We said not only was the Court of Appeals panel right, we believe, in interpreting the state constitution to provide greater rights than the federal constitution, but we couldn't write a better opinion if we tried. And so we quashed certiorari and let that Court of Appeals opinion stand. A few years later, we had another case where we had to decide whether to extend that principle a little bit, and we wrote an opinion on that case. But that's an example of one where we essentially endorsed the decision of the Court of Appeals, which became the precedent of the state.
Got nothing.
Let me introduce another concept that again takes us back to in the general vicinity of the topic that we were having discussed this morning, and that is whether state courts, state appellate courts, initially state trial courts, are laboratories of democracy. But more than that, maybe drawing an analogy from Eighth Amendment cases, where I've been known to dwell on occasion, that the concept of evolving standards of decency, and in a way this is the flip side of originalism, that both in an individual case in state court and in the overall national effort on an issue that extends from beyond one state, which obviously has been part of the discussion today, whether looking to what changes have taken place in the society generally or in the courts of other states is legitimate as a grounds for making decision, for deciding whether this is something that the state courts should step into or should back off from.
So I do understand that concept more at the U.S. Supreme Court level. The U.S. Supreme Court is making judgments that will then impact the entire country, and they've certainly had the experience of seeing what can come of a given right if the country wasn't necessarily prepared for that right. I still, and so I think I'm clearly referencing abortion. I still think the proper answer for the court was what it did in Roe, and without protection of what they acknowledged was a fundamental right to bodily autonomy, how that would have made its way through the states would be pretty grotesque, and the right would be pretty meaningless. And that's what we're looking at with Aiden dying. Now, in the state, at the state court level, I think it's difficult to translate the Supreme Court, looking at the evolving standards of decency and the groundswell and what's happening in the laboratory of the states. First of all, there has to be one state that does it first. If they all took that position, it's just never going to happen. And secondly, again, fundamentally, the Constitution, at least as I like to conceive of it, protects the rights of the minority. And even though Aiden dying is actually something that when you poll folks, it's more popular than same-sex marriage, it hasn't gotten a terrific foothold in lots of state legislatures. And so here people stand, something that they very much want, and it hasn't been recognized in court. And the sea change notion or the evolving standards, if that's what we're waiting for, is sort of like, all right, everybody's come around to thinking you deserve this right, so now we'll recognize it. And I think that is somewhat backwards.
I think part of this goes full circle back to your question about originalism. Because, again, if I'm arguing on the originalist side, then what they did in Missouri or North Dakota is of zero impact. And I will argue strenuously that it should be of zero impact. If, however, I, again, don't like what the originalist position is and I want to go broader, then I would argue that what's going on in these other states, depending on any number of factors, how similar their constitutional provisions are, the time of their constitutional enactments, any one of those things will give me 50 possible new sources to argue for, using your specific example, how decency is evolving outside of the territorial borders of the state of New Mexico.
Let me suggest a different way of looking at the question with which we began, or one of the early questions, for those who can remember back that far, which was the extent to which a question could be removed from the table of the legislature by a state court, particularly an appellate court, saying, no, we get to decide this because the state constitution, as we interpret it, precludes you from doing that which you want to do. The other way to look at that, and again, some of the discussion this morning on the physician-assisted suicide cases raises that, and the analogy that a couple of you have drawn to the abortion cases also raises it, which is, in one sense, it's taking it away from the legislature. In another sense, it's taking it away from the people. That the people are told, I know that's what you want, go suck a radish. That we know better. To what extent should state courts be cautioned against substituting their judgment for what they deem to be a less valid judgment by the people as expressed through the legislation? I raise it with regard to abortion because critics of the abortion decisions, including Justice Ginsburg, have suggested that one of the difficulties, unanticipated difficulties, was that in the Supreme Court, taking that question out of the political process sort of stunted what would otherwise have been a more natural development of public opinion.
Why is everyone looking at me?
Because you're the people.
Well, but we say, and our constitutions say that there are some things that are not up for majority debate. And that was absolutely Dr. Morris's point this morning. That has been stated time and time again by SCOTUS. And I think they've gone so far as to say, religion shouldn't influence my ability to exercise my rights of privacy, and if there is no protection from the judiciary, that's what it is. We don't have the ability then, or the protection of our ability to make decisions that make us distinct, that make us individuals. And all of those rights, I feel very, very strongly. I would fight as hard as I fought for physician aid in dying, for somebody to make another choice, whatever that choice was. I just believe those decisions shouldn't be subject to a group of folks raising their hands.
Any thoughts on that?
I'd say I 90% agree with what Laura said. But on the other hand, and going back to your reading of de Tocqueville, Justice, there is this concept that when the majority does speak, it is entitled to a certain amount of deference, and that the beauty of the republic that was established under our Constitution is, if you don't like what the majority you elected did, throw the bums out and put in a better class of bums to do your bidding. And if they...
How's that turned out, Andy?
I'm paraphrasing de Tocqueville there. But I think that's a constant struggle. And Jim, I think anytime you teach constitutional law, or any course that requires constitutional interpretation, that is, I think, a key thing to impart to the students. That constant tension between when is it Justice Daniels and Judge Vanze's job, and when is it the will of the people? And where does that line get drawn? And if I could articulate where that exact point is, I would probably sleep better at night.
I'm taking from that you had a very good constitutional law class with Professor Schwartz. Rather than prolong this further, and the next question on the list was to require everyone on the panel to use the word interstitial in a sentence. Let me turn this to the next and concluding part of the seminar, and please join me in expressing our appreciation to members of this panel. It was terrific.